Hello, Michigan Realtors, and welcome back to the Letter of the Law. This segment will address the question of whether or not realtors are liable for errors or miscalculations in square footage. Now, the following fact pattern or variations thereof may be familiar to realtors. The buyer of a house sues seller and seller's real estate agent for fraud and or negligence, alleging that the seller and agent overstated the square footage of the house. The alleged misrepresentation may have been made in the MLS, a print advertisement, or verbally. The information relied upon by the agent in making the square footage representation most likely came from information provided by the seller in the form of architectural plans, an appraisal, or tax records. Now, can the agent be found liable for the alleged misrepresentation? This segment explores how courts across the country have answered this question. In the majority of cases, the question of realtor liability turns on whether the buyer can show reasonable reliance. That is, can the plaintiff buyer prove to the judge or jury that it was fair and sensible for him or her to rely on the square footage information provided by the seller and or seller's agent? Now, in a recent case in Ohio, the buyer sued the sellers and the listing agent for negligently or fraudulently misrepresenting the square footage of the house they had purchased. The actual square footage of the home was 1,445 square feet, but had been misstated in the MLS printout as 1,991 square feet. Now, the Ohio court determined that the buyer's reliance on the accuracy of the MLS information was unjustified because the buyers had inspected the house 3 times before closing and could have measured the total square footage themselves or hired someone else to measure it for them. In addition, the court relied on the fact that the MLS printout contained a disclaimer of any liability due to errors and omissions in the information provided. The court dismissed this case, and the agents were found not liable for misrepresenting square footage. Some courts, however, are trending the opposite way and finding that agents are liable for misinformation. An Oklahoma court found that the buyer was entitled to rely on a listing broker's statements about the size of the home. In this case, the buyers sued the seller, the listing broker, and the listing agent for fraudulent misrepresentation in the MLS as to the square footage of the home. The home was represented as containing 2,900 square feet when the actual size was only 2,200 square feet. Now, this Oklahoma court held that statements of fact, like statements regarding square footage, actually discourage buyers from conducting their own investigations. Additionally, the court cited an Oklahoma statute which requires a licensee to deal honestly with all parties to the transaction and to exercise reasonable skill and care, obligating the listing broker and listing agent to determine the truth or falsity of any facts they represented. In some cases, courts have focused instead on whether a buyer has actually been harmed as a result of an error in presenting the square footage of a home. For example, a Texas Court of Appeals considered the issue of whether a buyer could recover damages as a result of a misrepresentation of a home's square footage. In that case, the listing broker and listing salesperson, through a mathematical error, incorrectly listed the square footage of the home in the MLS as 4,200 square feet. The actual square footage of the home was 3,600 square feet. Now, after closing, the buyer learned of the error from an appraisal report and filed his lawsuit. The buyer requested over $50,000 in damages, which he calculated by multiplying the square footage purchase price of $81.37 per square foot by the missing 625 square feet. The case went to trial where the court denied the buyer's claim to damages, finding that because the purchase price was actually less than the appraised fair market value of the home, the buyer was not actually damaged. Now, in Michigan, the Court of Appeals has looked at the issue of square footage misrepresentation claims on 2 occasions. In the first instance, the broker was found liable for misrepresenting the square footage because the agent made the mistake recklessly. The court unfortunately did not elaborate on the facts which supported the jury's conclusion that the mistake was made recklessly. In a later Michigan case, the listing broker and agent were found not liable. In this case, the court concluded that the buyer could not have reasonably relied on the square footage representation because the listing advertisement, which contained the square footage statement, expressly stated that it was not guaranteed and should be independently verified. The court also found noteworthy that the purchase agreement contained similar language, and the buyer had made several visits to the home, had an independent inspection performed, and received an appraisal report all before buying the home. On these facts, the Michigan Court of Appeals threw out the buyer's claims against the listing broker and listing agent. So what can realtors do to protect themselves against square footage misrepresentation claims? First, realtors should be aware that in many instances, square footage calculations for the same property may differ as between an appraisal, a building permit, architectural drawings, and tax records. While many times the variance in the square footage calculations might be due to human error, in other instances it is attributable to different methodologies or purposes for which the calculation was made. Some reasons for miscalculations include: assessors may round up or down, creating a 10% disparity. Architectural drawings can include garages and porches in their square footage calculations, while other calculations do not. Calculations of homes with sloped ceilings can create square footage issues based on whether there is 5 feet of headroom in the areas with sloped ceilings. If not, technically the square footage should not be included. Homes with living space below grade lend themselves to discrepancies in square footage since, although true living space should be above grade, many times the sub-ground level is included. And finally, an obvious disparity will occur based on whether the square footage measurements are taken on the outside walls or from the drywall in. As a best practice, when transmitting square footage information, realtors should identify the source of that information. Buyers should also be encouraged to independently verify square footage calculations. Realtors should use limiting language and/or releases contained in the MLS, the purchase contract, and other forms. And while these forms and disclaimers aren't foolproof, some courts have relied on such language in making their determination as to agent liability. Finally, realtors should describe the square footage as an estimate, using the word approximately to convey that the information is not intended to be 100% accurate. Realtors should also be careful not to imply that the value of the home can be conclusively established by multiplying the square footage of the home times a particular dollar amount per square foot. As always, thank you for tuning in to this installment of the Letter of the Law series. If you have questions or suggestions for new topics, please send those to the email listed below. Thanks for watching, and we'll see you next time.